Court does call the case of the people of the state of Michigan versus LDA Skinner.
Morning, Your Honor. Raymond Cook for the people.
This is Public Defender Natalie P. on behalf of Mr. Skinner, who stands to my right. Please say your name for the record, sir.
Dr. Thank you.
Your Honor, this is the date and time set for preliminary examination. The people are able to proceed.
All right. Ready to go? Let's go.
Just as a preliminary matter, there is an exhibit, People's Proposed Exhibit 1. I've discussed with the defense counsel some cell phone footage from the incident. I believe that that's going to be stipulated to being admitted.
That is correct, Your Honor.
Exhibit 1.
Correct.
For the purpose of preliminary examination, Your Honor, yes.
Okay, very good. You may proceed.
Thank you. The people call Brent Bucknell.
Please come forward. Be sworn.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God? State and spell your first and last name for the record, please.
Brent Bucknell, B-R-E-N-T, B-U-C-K-N-A-L.
You may inquire.
Thank you. Good morning, Mr. Bucknell. How are you? Mr. Bucknell, where were you on April 10th of this year in the afternoon hours?
I was in downtown Ypsilanti.
What were you doing in downtown Ypsilanti?
I was transporting packages from my place of employment to the post office.
And where is your place of employment?
The Rocket Gift Store, Michigan.
And you said in Ypsilanti, is that here in Washtenaw County?
It is.
All right. While you were transporting these packages, what route were you taking?
I was going south, crossing Michigan Avenue on Washington Street.
What did anything happen out of the ordinary while you were transporting those packages?
I passed the defendant on the right, leaving about 3 to 4 feet of space between us.
And when you say you passed this individual on the right, were you on foot, in your car, on a bike? How are you transporting?
I was on foot.
What about the other individual?
He was on foot.
All right. And do you see that individual in the courtroom today? Can you please point to him and identify him by an article of clothing that he's wearing?
It's the man wearing a green shirt.
Your Honor, if the record may reflect that this witness has identified the defendant.
Without objection, record shows so was left.
When you passed by the defendant, what were you doing specifically?
I was transporting packages. One hand was holding a bag of packages, and the other hand was pulling a larger package.
And at the time that you passed the defendant, what was he doing?
He was standing on the sidewalk.
Okay. And how much space was between the two of you when you passed by him?
3 to 4 feet.
When you passed by the defendant, did he say anything to you?
He did.
What did he say?
He said, "You should say, 'Excuse me, bitch.'"
What happened after that?
This is the turning point. Up until now, it's been a heated back and forth. But the second we hear threats meant to intimidate, like "I'll put you in a body bag," it stops being just talk. In legal terms, intimidation can cross into assault by threat. Words alone, if threatening enough, can become criminal.
I ignored it.
Were you able to continue walking?
Yes.
How far were you able to continue walking?
10 feet.
What happened after you got to that 10 feet?
He began making statements in an attempt to intimidate me.
And when you say he, are you still referring to the defendant or some other individual? Okay. What sort of statements was he making?
He was saying, "I will put you in a body bag. I run this street. I will shoot you. I will stab you."
How did that make you feel? Did the defendant ever get physical with you?
Yes.
When did that happen?
That happened about 10 feet later, going south of Washington.
So about 20 feet then from where you initially passed the defendant? What did he do that made physical contact with you?
He punched me in the face.
How many times?
Probably about.
Let that sink in. Not a quick shove, not a single heated strike, 20. That transforms the situation completely. Courts take the number and severity of hits seriously. One blow could be dismissed as a flare of temper, but 20 shows intent, aggression, and escalation, enough to push this toward aggravated assault.
20 times? Right. And when he first punched you in the face, did you see it coming? Was it from behind? How did that happen?
I saw.
All right. What did you do when you saw that punch coming?
I tried to push him away.
Were you successful in pushing him away?
Yeah, but he got on top of me and began to attack me some more.
When you say he got on top of you, are you on the ground now or are you still standing?
He pushed me down and I was on the ground.
Okay. How long was he on top of you?
10 seconds.
And while the defendant was on top of you, what was he doing?
He was punching me in the face.
Okay. What got the defendant to get off of your body?
I managed to stand up.
So you managed to get yourself up and push him out of the way? Okay. After you were able to stand up, what happened next?
He said, I will shoot you, I will stab you, I'll take your packages. And he also kicked the larger package that was on the dolly.
Okay. At that time, did he have anything in his hands?
Not that I saw.
Did he ever have anything in his hands?
He did.
What did he have in his hands?
He had a large flat blade mechanic style screwdriver about 10 inches in length.
When did the defendant get that screwdriver?
As he was running away towards the groin property next to the vehicle.
So when did he run away?
After punching me in, after I managed to get up.
Okay, so he gets you on the ground, you get him to get off of you, and then he runs away. Is that what you're saying?
I pushed him to the wall to defend myself, and then he runs away.
Okay. What were you doing as the defendant was running away?
I got my phone out to record it
Why did you get your phone out?
because I wanted to have his identity verified.
Had you met the defendant prior to that day? Okay. Were you able to record the defendant? What happened while you were recording the defendant?
He said, I'll stab you. And he continued to run away.
At any point, did he raise the screwdriver or threaten you with that screwdriver?
He did.
When did that happen?
As he was running away from the
And here comes the screwdriver. Suddenly, this case jumps to a whole new level. Even if he didn't stab, just pulling it out or threatening with it could count as a dangerous weapon. In the eyes of the law, an ordinary tool becomes a felony-making device when used to intimidate. The jury would have to ask, was this a weapon or just a prop in the chaos?
vehicle towards the groin property.
And what did he do exactly with the screwdriver that threatened you?
In his hand while verbalizing on static.
Do you know how far away the defendant was when he made that statement?
About 15.
Okay. When he raised the screwdriver and threatened you with it, what was going through your head?
I was concerned about the stabbing, so I did not pursue it further.
So you believed that he would stab you.
Yes.
All right. And after the defendant makes this statement, what happened next?
He continues to run away onto Brian Hope's property.
Did you follow the defendant?
Not after he made that statement.
Okay. I'm going to try and hook up and, if I may, publish or going to move to admit what's been marked as People's Prosecutor Exhibit 1. I believe it's been admitted by stipulation at this point.
Exhibit 1, if I haven't said so,
Thank you. May I publish?
you may.
Just for the record, I put up People's Exhibit 1 just before I start playing this. Sir, do you recognize this still frame?
I do recognize this.
And is this the video that you took depicting what happened that day?
It is.
All right. I'm going to play People's Exhibit 1. It's a video about 19 seconds long.
No, help! Stab you!
We can take, perfect, thank you. No further questions, thank you.
Cross-examination.
Thank you, Your Honor. Well, Mr. Bucknell, my name is Natalie P. I'm an attorney for Mr. Skinner. I just have some questions to ask you to follow up on your testimony that you given to the court today, if that's okay. If at any time you either don't hear my questions or frankly they don't make sense or you just need me to repeat it for whatever reason, let me know and I'm more than happy to do so. So at the time of this incident in April, you were an employee of the Rocket, and that's like a gift toy store, right? And do you still currently work there? And how long have you worked there?
14 years.
14 years. And you testified that you were on your way to the post office at this time, correct?
Correct.
And I believe you testified that it was like a dolly you had your packages on, right?
I have a larger package on the dolly and smaller packages in the blue idea.
And is this dolly, is this something you like pull, for lack of a better term, with a handle behind you? And how large would you say that cart is?
It's a retractable cart, and when extended, it's about 4 feet high.
Okay, thank you. And so when you were walking with your packages on your way to the post office, you bumped into Mr. Skinner with your cart, correct?
No, that's not.
At one point, however, he did turn around and tell you something to the effect of, you could have said, excuse me, correct?
He did say
And some sort of verbal altercation ensued.
correct.
And this was right outside of the beer cooler in Ypsilanti, correct?
The initial patient was inside the tap.
Inside the tap room?
So started outside the private property and continued outside the tap.
So we obviously all just saw the video that we watched, and you took this on your cell phone, correct? And you'd agree with me that Mr. Skinner is walking away from you in that video, correct?
In the video, yes.
And you'd also agree with me that the video depicts you continuing to follow him while filming, correct?
Correct.
And this video does not depict Mr. Skinner following you?
It does not.
And you would also agree with me that Mr. Skinner, we did see in the video that he did hold up a screwdriver, correct? You'd agree with me that at no point did he walk towards you while having that screwdriver in his hand, correct?
He turned around, but did not walk towards me.
Thank you. So just a couple other questions, Mr. Bucknell. I may have missed it when you were testifying about how the screwdriver came into play, and maybe honestly, I'm just a little bit confused. So how I understand it, there was a verbal altercation and then some sort of tussle. Where did the screwdriver come from?
He must have had it on his person.
Did you see it at any time before this altercation? And during the verbal altercation in this mutual tussle, did he at any point take out the screwdriver if he had it on him? So you testified today that Mr. Skinner threatened you or threatened to shoot you. Did you at all any time see him with a gun? When he made these verbal threats, did he present any sort of weapon? Did he present any sort of object at all when he made these threats? Did he even have anything in his hands? Thank you, Your Honor. No further questions for this witness.
Any redirect?
No, Your Honor, thank you.
All right, thank you. Sir, you may step down.
Your Honor, the people have no further witnesses and would rest at this time.
Any witnesses for the defense?
No, Your Honor.
Do you have a motion?
Your Honor, the people would move for bind over on count 1, felony assault with count 2 to follow. I believe the evidence the court heard was that the victim was walking down the street just doing his job. When he passed by the defendant became agitated at him and then proceeded to punch him. I believe the testimony was about 20 times, getting the victim on the ground. While the defendant was fleeing from that assault, the victim recorded him, and the defendant, as the court saw, raised a screwdriver at him and said, "I'm going to stab you." He raised it in a threatening manner. I believe that the evidence shows by a probable cause standard that an assault occurred where the victim did state that he was afraid.
Well, why would that be an assault on this individual? Why, I'm talking specifically about the felonious assault.
Because the screwdriver, I believe, is a deadly weapon that satisfies that element, as opposed to why it's an assault. That's because he raises it, threatens him. I believe the victim testified that he was afraid that he was going to get stabbed, and he said as much, and that's why he stopped following him. So I believe that shows that he had that apprehension of an immediate battery.
I get that, but at the same time, the physical altercation which occurred on the ground with the 20 punches to the face, that has transpired. As I understand the witness, they then testified that that attack is over.
Correct.
The defendant, according to the testimony of the witness, then is leaving the scene.
Yes.
The witness then follows that
Correct.
and is in essence saying, leave me alone.
The defendant is making statement, yes, I want,
Yeah, and says what he's going to then do.
yes.
So at that point, why is that an assault? Why he is
The judge zeroes in on the heart of the matter. If Skinner was retreating, does waving the screwdriver still count as assault? That's the razor's edge of this case. Was it a desperate final threat, or simply an act of defense while backing away? These subtleties matter because they decide whether the charge sticks as a felony or gets reduced.
retreating from, assuming given the testimony occurred, a bad act has occurred. He is then leaving from that bad act.
Yes.
He's then followed by Mr. Bucknell
Yes.
and then turns, and that's when he says something.
Yes. And the people's argument is when he makes that turn,
Go ahead.
when he makes that turn and makes that statement, I believe the video showed him raise his arm and lift the screwdriver in a threatening manner. And given that motion and the victim's statement that he stopped following because.
But why would that be an assault by him?
Because he's making the victim fear an immediate battery.
But only because the Mr. Bucknell is following.
Yeah.
That's the only reason. The only reason that that portion of the altercation occurs is because Mr. Buckman goes after him.
Yes, and I believe the victim testified the reason he was recording was in order to get the defendant's identity due to that assault. He was trying to make sure that this could be responded to. I don't believe that following a defendant gives that defendant the right to then threaten that individual with a screwdriver, especially in an area that's open to the public and there's no reasonable expectation of privacy.
I don't know where the privacy issue comes in, but okay. All right. Response.
Your Honor, I would object to the bind over on the count of assault with a dangerous weapon. I would argue, Your Honor, that there was no assault with a dangerous weapon or the screwdriver. The complaining witness did testify that Mr. Skinner at no time stepped towards him while the screwdriver was in his hand. Obviously, we all saw the video and that Mr. Skinner did raise his hand up while holding a screwdriver while he was being followed. He made no movement and did not put the complaining witness in a position of a reasonable fear of a battery. Given the nature of the weapon also being a screwdriver, to be candid, it's not a gun. Without any movement towards the complainant, my client would not have been able to assault him with a dangerous weapon. That being said, Your Honor, I would object to the bind over, and I do believe even by
Well,
problem.
he wouldn't have to necessarily make a movement. He would just have to have the ability to come into contact. Which if he had run in the direction that the camera was pointing, he could have done that.
Absolutely, Your Honor. If he had run that way or chose to flail that object in his direction. But of course, that's not the situation we have here. Mr. Skinner, there was some sort of fight. I won't dig into that. Mr. Skinner was walking away from it. He had an object in his hand. He was being followed. He turned around and told the complainant whatever he said, and I would argue that the people did not meet their burden even by a probable cause standard and object to the bind over on this felony charge, Your Honor.
Anything additional from the people?
No, Your Honor.
In this case, the court listening to testimony, Mr. Button, and I think it's important to face the court's distinction as to what transpired based upon the testimony of Mr. Button. There was first this assault, which occurs where he's indicating that he's punched 20 times. At some point, he's on the ground, but he then gets himself up, and the defendant is up at that point in time. The defendant, strangely enough, begins, and I'll call it a retreat. He basically begins to retreat. It is then Mr. Bucknell that is continuing. He may have his justification for what he's doing, but he's continuing the potential altercation as he's following it. It is at that point, and remember, Mr. Bucknell's testimony is that he doesn't see the screwdriver. He's only presuming that it's on his person. Don't know that, but he's presuming it's on his person at the time of the initial assault. But the defendant is leaving. He's following for the purposes of identification. The threat, there is no longer a threat to Mr. Bucknell, other than the one that he is then creating. The defendant turns around, says what he's going to say, raises the weapon. Because of that time frame, the defendant, while he may not have acted right, at the moment that is happening, he is not acting unlawfully in what he's doing, and would be entitled to be there and potentially defend himself from what may be an oncoming assault of Mr. Bucknell. Maybe, I don't know. So for those reasons, and the court looking at these as two very distinct acts, as I listen to the testimony of Mr. Bucknell, the court is going to decline.
And here's the verdict on that point. The court refuses to bind over on the felony charge. No assault with a dangerous weapon, only aggravated assault. It's a huge distinction. Skinner dodges the more serious felony, but the beating still keeps him in hot water. In the end, the screwdriver wasn't enough to tip the scales.
To bind over the defendant on the assault with the dangerous weapon, finding that at the moment that weapon is exposed, it's not an assault with a dangerous weapon. It could be a number of different things, but it's not an assault with a dangerous weapon. And we'll remand it on the aggravated assault to 14A2.
Thank you, Your Honor.
I will set pretrial on count 2.
September 24th.
September 24th, 2025, 10 a.m.
Yes.
10 a.m. before Judge Barr. Bound with its conditions will continue.